up, guys? Welcome back to my channel. I'm back with another little Durk video, and it looks like he got some bad news. The judge in his case denied his motion to throw out the indictment. So let's get into this article by courthousenews.com and find out why. Chicago rapper Lil Durk on Tuesday failed to convince a judge to throw out the M for hire charges against him and 5 of his associates based on their argument that the government's indictment is so vague that they can't prepare a proper defense. Federal prosecutors accused the Grammy-winning hip-hop artist, whose legal name is Durk, Banks, of having offered a bounty for the M of a rival rapper, but Christy O'Connor, one of Banks' attorneys, said at a hearing in downtown Los Angeles that the indictment is impermissibly vague about the specifics of what the bounty was and how it was offered. When you have an indictment this vague, you can't fill in the blanks with material the grand jury didn't see, O'Connor said. The grand jury has been usurped. Typically, prosecutors will present their evidence behind closed doors to a grand jury to determine if there is probable cause that a defendant has committed a crime. According to O'Connor, while the government has given the defense purported evidence such as music videos, the attorneys don't know whether that evidence was shown to the grand jury as proof of Banks somehow offering a bounty or it's evidence intended to be introduced at trial. O'Connor also claimed that a key government witness, identified only as protected witness number 1, told investigators that he hadn't been offered a bounty at all to participate in the M attempt on Banks' rival in LA 3 years ago, in which a cousin of the target was unalived. This, she said, creates the danger that the prosecution is shifting its theory of the case and that the defendants will be confronted with a trial by surprise. U.S. District Judge Michael Fitzgerald, however, said the defense wasn't entitled to a blueprint of the prosecution's opening statement and that the defense attorneys would be able to cross-examine the government's witnesses at trial to show the jury if they had changed their story. The Barack Obama appointee denied the motion to dismiss the indictment, which he said met the requirements used in the Ninth Circuit, but he postponed a ruling on the defense's request for a bill of particulars that would spell out what the prosecutors believe Banks said and did to direct the hit on his rival. Fitzgerald also rebuffed Banks' request that the judge recuse himself from the case because the prosecution had waited 7 months to disclose to the defendant that death threats had been made against the lead prosecutor on the case, as well as a magistrate judge who earlier this year had denied Banks and the others bail after deciding they were a flight risk and a threat to the community. Although the threats weren't made by the defendant, the fact the prosecutors hadn't told the defense attorneys about them when they went before the magistrate judge to argue for pretrial release has tainted the entire proceedings, said Drew Feinling, another lawyer representing Banks. They looked at this as a serious threat, Feinling told the judge. There is no rationale for letting us walk in front of Magistrate Judge Patricia Donahue and make fools of ourselves. We truly had a ridiculous hearing. To state the obvious, Judge Donahue was in no position to consider whether Mr. Banks was too dangerous to be released while having been both personally threatened by someone purporting to act on Mr. Banks' behalf, Banks said in his bid to disqualify not only the judge presiding over the case, but the entire bench of the U.S. District Court for the Central District of California, as well as the U.S. Attorney's Office in L.A. Banks and his co-defendants demanded an evidentiary hearing into the threats and the prosecution's response to it and asked that the case be stayed. Fitzgerald rejected this request as well, saying that even if a defendant would threaten a judge in open court, that wouldn't be a reason for a judge to recuse themselves. If it were to work like that, it would give an incentive to a defendant to make such a threat just to derail a prosecution, he said. Banks was arrested a year ago in Florida on charges that he orchestrated the attempted 2022 revenge unaliving of rapper Quando Rondo at an LA gas station, a pow-powing that resulted in the unaliving of Quando Rondo's cousin. He is charged with conspiracy to commit M for hire and the slaying of the cousin, 24-year-old Xavier Robinson. 5 members of Banks' Chicago-based rap collective, Only the Family, or OTF, have been charged. You guys let me know what y'all think about this in the comments down below. I'll just say this. It ain't looking too good for Durk, but stay tuned to the channel because I will be following this case and I'll be back with more updates as they come. Right now, he is set for trial January 20th of 2026, and I will be covering the trial. So go ahead and lock in with me now if you haven't already and subscribe. And thank you guys so much for watching. And if you like this video, please hit the like.